And thank you.
If I can just say, if your loved one is missing, file a missing persons report, even if they're not under the LPS conservatorship, and let them know they have a mental illness. They're a disabled adult. They go right to the top of the missing persons list, right under missing children. Right. But now there are only 4 detectives in Los Angeles to find them. So there's only so much they can do. They can check like the jail, and if they, hear of them or something like that. But nevertheless, at least do that. If you know the area they're in, I've had people go down like to Venice Beach or Santa Monica or whatever. Be sure it's a safe place with their picture. Talk to the homeless there. Show them the picture. Let me tell you, the homeless know everybody on the street, and they know when somebody's new on the street. And they'll tell you, yeah, I saw them over there. So don't hesitate to do that. And that's really important. If they're under the LPS conservatorship, they can let you know when they find them, and they ask you, what do you want us to do? Now, if they're not under the LPS conservatorship, the police will call and say, yes, we have them. They're doing fine. Where are they? I cannot tell you. So just tell the police, look, thank you so much. I appreciate this. I'd like to get you a cup of coffee. Could you tell me what street you are on so I can find the nearest Starbucks for you? They can tell you that, but they can't tell you where your loved one is. So you kind of have to think about things when you talk. You just change the wording a little bit. Okay, next slide.
Yeah. It's really? Yeah, there we go.
Yeah. Okay, and next slide. Yeah, if you can donate, it would be greatly appreciated. If you can't, don't, okay? Because I know you're spending a lot of money helping your loved ones. This is only if you can. We appreciate it. We've got time for questions. A few. And one question I saw somebody ask, can they be the conservator if they're not living in that county? Yes. I was conservator one time, and I'm living in Louisiana. I'm in Florida now. But, and I go back and forth. Different
recording stopped.
Different people are in different areas. So as long as you can come observe the places, be with your loved one here and there when it's needed, you can be a conservator anywhere. They prefer if you are here, but if you're not, it's okay, as long as you are involved. Okay, and yes, a person can have private insurance. Questions?
Yes, so I have muted the recording. Again, still refrain from exposing too much names, information, but feel free to use the chat or just raise your hand so we can unmute you. We do have about 15 minutes to ask and answer some questions before our next presentation with Connie.
No questions?
Yes, we have Wilson, Sharon raising their hands. I believe they're both unmuted, so whoever wants to go at it first.
Hi, I just kind of had a general question. I don't know if it's somewhat related, but my sister receives SSDI, and I believe she has Medicare too, or both. I think you said. And it's been this way for about 20 years. And recently, my mom was on a three-way. I was on a three-way call with her to talk about her retirement, and then the retirement customer agent or something like that said that neither her or her biological father claimed her on their taxes or when they applied for retirement, and they made it sound like it was something really bad that that she was going to get punished for, or that my sister was going to get punished for. They might have to recalibrate whether my sister is still eligible for mental health, the Social Security. And I was just wondering if you had any idea about that.
I think in that case, you would be better off talking to an accountant. Something doesn't sound right. I think I would call Social Security and talk to them. They would probably have the particulars and maybe an accountant. I mean, I'm not going to get into that because I don't know really
Okay.
all the particulars and all. I'm not a tax person.
Right. Okay. Well, thank you so much for your help.
Hi, this is Sharon Smith. I had a question. My son, he's 34. He's been homeless since he was about 18, 19 years old. He was hospitalized at one time. And since then he's been kind of in and out of jail. He's been on a number of 5150s through LAPD. Which I don't really know what hospital they take him to. I don't know when he's on a 5150 hold. Right now he's homeless. He won't allow us to put him in a place. He does qualify for SSI. Matter of fact, he was approved, but he won't allow us to house him. So my question is, like, in that case, like, we know where he is right now. I mean, how can I go about, and mental health, the Department of Mental Health has been involved. They have tried to come out and engage him and kind of get him to seek treatment, and he won't do it. He runs away from them. So my question is, what can I do to get a conservatorship process going to try to get him treatment?
Okay, let me ask you, is it AOT assisted outpatient treatment that has gone out to engage him?
I'm not, I believe it is, because I actually applied for the AOT, and when he was in jail, they contacted me when he was in jail. I'm not sure if it's FSP. I mean, I have the social workers' information. They have tried to go out there and engage him. He was supposed to go to court. He didn't show up. From what I understand, I think either the psychiatrist or the public defender have tried to go out. They couldn't locate him. But like I said, when the Department of Mental Health have gone back out there to try to engage him, to get him to, get treatment, he runs from them. He runs.
Yeah, that's like keep a journal so you know exactly who's trying to do what.
Okay.
So is it AOT or a full service partnership? And that's one that Connie, is this one that you can handle? Is Connie on this right now?
I'm on, Gail. I will talk a little bit about our home pilot. So why don't we wait until I get through my presentation and see if that answers questions.
Okay.
Sounds good. I'd like to add one thing, that when a person is in the hospital, if you're applying for, they either have SSI or SSDI, and they're spending their money like a drunken sailor. When they are in the hospital, ask the treating doctor, or if they're in a program, if you need it, to fill the form for you to become representative payee.
Well, can I say something? I am the payee over his SSI. However, because he won't allow me to, he wants the money in his pocket. He won't allow me to find him housing. Like he's like, he's okay and he's not okay. Every time we see him, we offer, and he's constantly refusing. So I'm not actually getting the money because he went to jail, they cut him off, and we never went back to tell him he's out of jail. So I'm not getting the money, period. But he has been approved. He was approved. You're gonna want to do. And so, but we just haven't went back and said he's out of jail and we need to resume the payments. But I am his representative.
Oh, good. Because when he gets out of jail, hopefully they'll put him in a program, and I would contact the treating doctor at the jail, give him the history, symptoms, and gravely disabled, and request the treating doctor to initiate that LPS conservatorship. Okay,
one more question. He's not in jail currently. He has been in jail for a while. I don't know, is it because they're doing the 5150 holds for him? But right now he's just on the street. And I do check the jail's, website whenever we can't find him or family members don't see him, but he hasn't been in jail for a while.
A 5150 doesn't take him to jail. That takes him to the hospital. But
Right.
if they go out there to do a 5150 and they find a crime, they can take them to the jail. And sometimes it's easier for the police to take them to the jail because they just sign off and leave. If they take them to the hospital, they have to wait for them to be evaluated and all this other role. So if they're closer to the jail, that's where they tend to take them. If you're further away from the jail, they'll tend to take them to the hospital.
Well, how can we find out when they take him to the hospital? Can we go on a system?
That you really can't because of HIPAA.
Okay.
But on that jail, they do have a website that you can go in and you can check every day and find out if he's in the jail.
Okay.
All right.
Okay.
Thank you.
We have Krista next, raised hands. If you want questions, please raise your hand so you can line up. Krista, are you unmuted?
Hi, yes, can you hear me?
Yes.
Okay, I guess to make it short, I just wanted to know, is there someone to contact? My son has just been made a 5250 and I want to go for conservatorship, and I've notified the hospital that I want conservatorship. We're in San Diego and he's at UCSD. And I just wanted to know, is there anyone to contact to guide me? I mean, this presentation was great, but my mind is just so bogged down with, the grief that it's kind of difficult to try and navigate it by yourself.
Yeah, you're more than welcome to call me. Okay. But keep in mind, right now I'm on the East Coast, so I'm 3 hours ahead of you. So when you get up in the morning and you're having a cup of coffee, give me a ring. Okay. And I'm a little bit different thing. So that USDS, they're pretty good about doing the LPS conservatorships in San Diego. So
I hope so. I have heard that San Diego is a little more difficult than LA for some reason. I guess we're just a little more liberal, down here or something. I'm not sure why, but I have heard it's a little more difficult in San Diego, but I'm just hoping that it will go through.
Can I put together that history, symptoms, and gravely disabled? I found everybody who's been in San Diego who's done that, they've had pretty good success. And now your public guardian is showing it on the internet saying do it. Okay. It does make a difference. Okay? But I'll do my best to help you.
Okay, thank you.
Krista, I put their information on the chat. You can find their email and their phone numbers on the chat.
Okay, thank you.
So the next one in line is Paula.
Hi, I am in Alameda County, and I don't know how many people on this are in other counties besides LA. Apparently, things are much easier and more regular or normalized there. In our county, we have a very difficult time with all of the things you've mentioned. We can't demand a police officer take the person to, and 5150. That's just doesn't happen here. But my first question, I put a bunch in the chat. If other people want to interrupt, that's fine. But my first question is, here, I'm told that the conservator can't approve or disapprove a placement, but that if the doctor or the other case managers place the patient in an unlicensed board and care, then the conservator must drop out as conservator. So is that different from your county and in your county? And if you know, is there a state law that states otherwise?
Connie, I'm going to ask you for help on this
because okay, I'll jump in, Gail, on this one. So I think the first question that I have is, what are the powers that you have been granted on the conservatorship? So in every county, the court is going to grant certain powers to the conservator. That could be the ability to have decision-making powers or decisions making powers over placement. So that's really the first thing. Every county can operate differently on how or what powers they give a conservator. In LA County, generally the conservator is going to get powers to place in any level of care, from a residence to a locked setting, to a IMD to an acute. So it just depends. Each county and the judge will make different decisions about what powers a a conservator gets. I will say, although, certainly in our county, we want to have family members, having as much say in placement, and Gail is giving you, really good information about, how to advocate for appropriate placement. But I will say that right now, your ability to choose a placement is very, very difficult in LA County. If an individual needs an IMD, the reality is that you will have to accept the first IMD bed that becomes available. If you don't accept that bed, you may lose the opportunity to have your loved one go into an IMD bed because we have such a long wait list. While we want to honor preferences, and we certainly would like to have family members.
Lost you.
We lost you, Connie.
Well, I'm a little, I'm going to ask another question in case she gets to it. And that is the state law, is there a state law that allows for a family member to become a conservator? Because I don't know any family member here who is a conservator, and it seems to me that maybe the family member wouldn't have to drop out as a conservator if the person is placed in an unlicensed facility. So I don't know. This is so different.
Yeah,
it's so different from what we do that I'm just very confused.
Yeah, it is very different. And I'm finding Northern California, the way they implement the laws are state laws. I find that they're strange, but if I can make a suggestion to everybody listening, get on that phone Monday morning, call your representatives and tell them, one, you want more treatment facilities. You have buckets of MHSA funding that's supposed to have originally go to serious mental illness, and it's going to every Tom, Dick, and Harry that is not seriously mentally ill. They've, excuse me, they've created all these programs, but you need the foundation. You need IMD beds. You need psych hospitals to be paid for. You need a better process for getting LPS conservatorship. This idea of, having to be in the hospital and be gravely disabled and get so sick before you can get an LPS conservatorship is so wrong. That's discrimination. What illness do you do this for? You don't probate. You can get that in very easy. Not a big deal. But mental illness, when the brain is having the same problem that autism, Alzheimer's, all of those are having, they make it a big to-do. So you see people on the streets and in jail. Call your legislators and tell them you want the laws changed. You will make the difference. Now, if I can just say something, what we did in LA, which started to make a difference, people would call me and they put together that history, symptoms, and gravely disabled. And I had them send it to, when the hospital's saying, we're not going to do it, they sent it to the director of DMH, Department of Mental Health. Some counties it's behavioral health care. And they copied every board of supervisors. On our paper, we have every email and phone number for all of our board of supervisors. These people work for you. So you should be able to contact them. And they would send them and they would say, we need this. Consequently, there have been a lot of changes in Los Angeles, which before there were not programs, there wasn't anything. It was terrible. It has improved a lot. It still needs to improve an awful lot. But when the board of supervisors are hearing these programs and your legislators are hearing the problems, they start to listen and they start to make a change. But you can't do anything about anything you haven't heard about.
Well, thank you very much. I'm a member of an advocacy group for family members, but just so you, I'd like to know if there's anything statewide that you would recommend connecting with.
First of all, the law that I read in the California Welfare and Institutions Code was they basically have to listen to the conservator and try to accommodate the conservator as best they can. And I would look at the powers granted under the conservatorship up in Alameda County. See what counties they gave you, and you can go to court and say, I'm requesting this power, a certain other power. And you might get it granted. It's worth a try.
Okay, thank you, Gail. So we are getting close to 3. I believe Connie is having Wi-Fi issues. She has not logged back in. Did you want to keep on taking questions until she popped back in to present?
Yeah, she is trying to get back in.
I'm not sure. I don't have her contact information, but she has been off the meeting for about 4 minutes right now. I'm assuming she's having Wi-Fi problems. So
I have a question.
Yes.
Go ahead.
Yuko Gold in San Bernardino County. We don't have AOT, so therefore, if I want the LPS, how would I get a hold of the staff personnel once he is admitted? Because I remember last time that they locked the door on me and they said that you have no right to contact your son once the door is locked and go away, basically. And I can't get hold of my son because my son does not know the, what's that called, the PHI form. And so after all that, they sent my son home. So my question is that how could I proceed LPS with hospital?
When he's in the hospital, put together that history, symptoms, and gravely disabled in the exact format. Don't change it. Okay. You can give the doctor a stack of information 2 feet high and they'll never read it. But this, in 3 seconds or less, they can tell there's a problem. I would give it to the doctor with a cover letter stating that you would like the LPS conservatorship. You probably will get a better response from that. Now, knowing the laws is important because they have to, by law, take your information. So,
Gail, I'm back. Gail, I'm back. My computer just died. I'm at work and they just shut down on me. So I'm back. So why don't we go ahead and get started so I can get through my material before my computer decides to die again. So
okay.
Yes, and we will continue questions after this presentation. Thank you.
Thank you.
Okay, sorry about that, everybody. And I know that I was in mid-sentence answering that question, but I'll try to get that information into my presentation as we go forward.
Recording in progress.
So my name is Connie Draxler. I'm the Deputy Director for the Office of the Public Guardian. Next slide. We're going to do an overview of the Office of the Public Guardian. We'll talk about conservatorship, the intent, purpose, and types of conservatorships. And then we'll talk about the conservatorship services that are available in LA County. My presentation is specific to LA County. As I was alluding to before computer problems happened, things can be different from county to county. Although we all are under the same law and follow the same conservatorship laws, implementation of conservatorship from county to county will be different. That depends on your public guardian or public conservator office, what department they are a part of, and what resources are available. So I am giving you general information, but also specific to LA County. It may not operate the same way in your county. Next slide. So the Office of the Public Guardian, or it could be the Public Conservator in your county, it depends on how it's structured. But the Public Guardian is the designated county conservatorship investigator for LPS conservatorships. So what does this mean? This means that all referrals for LPS must come through the Public Guardian or Public Conservator office, and only the Public Guardian can submit the initial petition for conservatorship. So we frequently get the question about whether or not you as a family member could go into the mental health court and file the petition for the LPS conservatorship. You cannot. The way that the LPS law is set up is that it must come through your county conservatorship investigator office, and in nearly every county, that's either the Public Guardian or the Public Conservator. There are a few counties in which the Department of Mental Health or Department of Behavioral Health might be conducting those investigations. So you really need to find out who do referrals go to in your county. That will be the agency that's going to go ahead and do the investigation and determine if they're going to petition for conservatorship. Referrals that are submitted to the public guardian's office can be accepted or rejected. We don't have to accept a referral. And some of the reasons why we will not accept a referral is that the individual is not a county resident. There is not any evidence in the referral about grave disability. The referral is incomplete, or the referral and particularly the declaration for conservatorship is not legible. I do want to spend a moment on the issue of county residency. This is a very important issue, and particularly important, I think, for LA County, because we have a lot of counties surrounding us, and if you happen to live on the border of LA County and your loved one happens to get hospitalized in LA County, but you live in Ventura, San Bernardino, Riverside, or Orange, the referral for your loved one, even though they're in an LA County resident, is to be submitted to the county of residence. So that would be the county that the person has been living in or has been transient in, even wherever that person has been for their extended period of time. We cannot establish residency because you're as a parent, you live in LA County, even though your loved one may be in another county. We cannot establish residency and make that an LA County conservatorship because the parent or the person that desires to be conservator happens to live in LA County. It is where the proposed conservatee is at, where they have been for some time, where their Medi-Cal may be. That may be a determining factor, depending on how counties look at their referrals, may be determinants of residency. Next slide. So what is conservatorship? It's a court proceeding in which you're going to appoint someone to be legally responsible for someone else who's unable to provide for their personal needs or maybe unable to manage their finances. There are 3 types of conservatorships in California. The first one is LPS, the Mental Health Conservatorship, and that will be the focus of this training. And then the probate conservatorship. This is generally for older adults who have major neurocognitive disorders such as dementia or are developmentally disabled. I want to caution people because many families will try to go get a probate conservatorship thinking that this can be a substitute for the mental health conservatorship, and it is not. You do not get the authority to medicate your loved one for with psychotropic medications for a mental illness. The only way that you could provide psychotropic medications is if the person had a major neurocognitive disorder such as dementia or Alzheimer's or a traumatic brain injury, and the psychotropic medication was for that condition. But if you are trying to medicate your loved one through a probate for schizophrenia, bipolar, one of the major psychiatric conditions, you do not get legal authority to do so in a probate. The only way to legally involuntarily administer medications, psychotropic medications for someone who has a mental illness is the LPS conservatorship. I will also caution that if you go do a probate, and anyone can do a probate, if you try to do it yourself, you can. We usually advise people to get an attorney to help them do that, and that can be up to $10,000. So you're spending $10,000 for a conservatorship that ultimately doesn't give you the authority or powers that you're looking for. And then there is the housing conservatorship. This is not available in LA County. This is a pilot conservatorship that was put in law a few years ago. And unfortunately, the 3 counties that have the housing conservatorship or who were authorized to do it, 2 of the 3 chose not to. That's San Diego and LA chose not to do this conservatorship. San Francisco did implement, but I don't believe that they've actually conserved anyone under that housing conservatorship. Next slide. The conservatorship's a civil proceeding. It looks a lot like a criminal proceeding, and there's a lot of elements in our conservatorship hearing that resemble a criminal case. For instance, in order to get someone conserved, you have to prove that they are gravely disabled beyond a reasonable doubt. That's actually a legal standing that you would normally find that you do find in a criminal proceeding, and you usually don't find that in a civil proceeding. But we are a civil proceeding, but we have elements of a criminal case that are imposed in our proceeding. You must prove that there is a need for the conservatorship, and there's usually a requirement of people having to attend court. Next slide. So what was the intent and the purpose of the LPS Act? So first of all, the LPS Act was created a long time ago, back in the late 1960s. And really, when you look at the time and place as to when the LPS conservatorship was established, it has its roots in many ways in the civil rights movement. Prior to the LPS Act being put into place, individuals could be easily and without any evidence, locked up in a state hospital, basically throwing away the key, and they never get out. There was never really any due process. There was no attorneys involved. There was no, protections for the individual. So the LPS Act was really created to kind of overcome some of the problems that were in place in the 1960s. Many people would indicate that it's time to reform the LPS Act. That's a discussion for another day. But one of the intents and purposes of the LPS Act, and this is still in the statute, in the law, is to end inappropriate and indefinite involuntary commitment, to ensure that people weren't just being locked up and never getting out of that locked facility. To provide prompt evaluation and treatment, so really created the whole 5150 type process. To provide for individualized treatment, supervision, and placement, and to safeguard their rights to a judicial review. So there is one thing you will find is that there is a lot of judicial review. There is a lot of court process in establishing a conservatorship. Some other intents and purposes is to provide services in the least restrictive setting. So it is not the goal of the conservatorship to have somebody in a locked setting. You should only have them in the setting that they need to be in. And then it also establishes procedures for involuntary treatment. This is not all of the reasons why the LPS Act was established, but it is some of the key provisions of the law. Next slide. What's the effect of conservatorship? So basically, you're going to shift the responsibility for making decisions about personal care and finances from the client to the conservator. So the client is going to, their civil rights or constitutional rights are going to be severely limited. So the things that you and I take for granted as an adult with, decisions on where we want to live, what kind of treatment do we want? Do we want mental health treatment? Do we want medical treatment? Do we want to sign a contract for something? How do we want to spend our money? All of those things are your constitutional right to do as you please. But when you are placed on a conservatorship, the individual loses the right to make those decisions by and large, and the conservator is making that for them. So despite the major limitations to an individual's civil rights, it can in fact maybe be the best guarantee of protecting the client's interests. Next slide. So this is just a few of the pictures that kind of tell you the process. This is a visual of how you may enter into the conservatorship process. And the picture of our Hollywood court there is down in the right lower hand corner. So the next slide, please. I am going to talk about the two ways in which LA County will receive referrals. This is specific to LA County and does not apply to other counties. So I am just going to talk about where the public guardian can receive referrals in our office, in our county. The first is our inpatient conservatorship process. So this is pretty much the same stuff that that Jim and Gail have been talking about in terms of an individual being in an acute hospital, an acute psychiatric facility. So I'm going to repeat a few things that you probably heard, but sometimes it's good to hear it multiple times because the process can be very confusing and complicated. So it starts generally with an individual being placed on a 72-hour hold, a 5150, being placed at one of our designated acute psychiatric facilities. So when I say a designated facility, those are facilities that have already been identified or authorized to place people in the hospital on an involuntary hold. They're designated. They are also the facilities that are designated to send referrals to our office. So every county should have a list of facilities that are designated to refer to the public guardian or public conservator. After the 3-day hold, if an individual cannot be discharged safely, they can be placed on an additional 14-day hold. This is the 5250. And then they can also, after the end of the 14-day hold, be placed on a 30-day intensive hold. And this is a 5270. This is another important distinction. Not all counties use the 30-day intensive hold. That hold has to be authorized by the Board of Supervisors in each county for that to be implemented. So it is possible that in some counties, or in the county that you live in or are dealing with, that they only have the 5150 and the 5250. So that's going to accelerate when a referral has to be sent to the public guardian's office. In LA County, we do have the 30-day hold. So we will frequently see individuals staying all the way to being placed on the 30-day hold, and that's when a referral comes to our office. The total amount of time that an individual can be legally held involuntarily is 47 days if your county has all 3 of the holds available. If you do not have the 30-day intensive, it would be 17 days, and the public guardian's office would need to take action before the 17th day of that hold in order to establish a temporary conservatorship for your loved one to continue remaining in the hospital. So in LA County, referrals come to us usually at the end of the 14-day hold or the beginning of the 30-day hold. There are very strict deadlines for submission of referrals. I know that Gail has frequently had to deal with family members who are distressed because by the time the hospital decided to make a referral to the public guardian's office, it is too late in the process. We have a legal process that we have to do. We have to get referrals in by a certain deadline in order for us to do the legal process, give notice, do an investigation, and do certain things. Next slide. So when we're talking about our inpatient or our acute hospital LPS conservatorships, we're talking about for persons who are serious mental illness who require involuntary treatment. The referrals must come from designated facilities, and there are designated doctors within those facilities that can refer. In LA County, there are over 40 designated facilities. That includes the jail. They are authorized to send referrals. I will comment, the jail is not always authorized in every county to do referrals to the public guardian's office. Next slide. So what's the due process? Again, I think Jim may have talked about this a little bit, so I'm going to go over it again kind of quickly. Not only do you have an individual on a hold, there is some other legal things happening even while they're in the hospital. As I said, this is a heavily legal process, this whole thing. So there are things called certification hearings. So when the individual is on the hold, there has to be a hearing to certify that they in fact should remain on those holds. So the 14-day and 30-day certification holds take place in the hospital, in the facility. And the legal basis there is that there's probable cause that the person is a danger to themselves, a danger to others, or gravely disabled. I will let you know that on the 30-day intensive hold, you must be gravely disabled. You cannot be held on the 30-day hold for danger to self or danger to others. There are other holds that can cover that if that's what the issue is. If there is an individual who's suicidal, or if the individual is homicidal, there are other holds that can be used other than the 30-day grave disability hold. At these certification hearings, there will be a patient's rights representative that will represent and help the the individual who's on a hold, and then the hospital personnel. And then there is an administrative judge from our mental health court who is participating and will make a decision if your loved one should remain on the hold or if there's insufficient evidence and they declare that they can be immediately released from the hospital. There are also Reese hearings. So just because your loved one is on a hold does not mean that they are involuntarily medicated. The hold is just to detain the person in the hospital. So if there is the need to actually involuntarily medicate while in the hospital on the hold, the hospital has to ask for what's called a Reese hearing. This is a hearing to involuntarily medicate. LA Public Guardian does not obtain involuntary medication powers in our TCON. Some counties do, we do not. So if an individual needs to be medicated on the temporary conservatorship, we would have to do what's called a TCON Reese. We would have to petition the court for that. Again, the legal basis is clear and convincing evidence. If you are talking about a 5250 or 5270 Reese hearing, that's going to be held at the facility. If you are talking about a TCON Reese, then that will be held at court. And then on top of all of that, the individual who is on a hold, your loved one, has the right to ask for a writ. A writ is going into the court and asking that they be released from their hold. So there's numerous legal hearings and processes that occur during the holds. Next slide. What's the legal basis? You've heard this before. It's gravely disabled. So that's the inability to provide for food, clothing, or shelter due to a mental disorder or impairment by chronic alcoholism. So alcoholism in LA County at least is rarely pursued if it's the primary diagnosis, because we do not have any treatment facilities that will focus solely on alcoholism. We do, if we have an individual who has a primary mental health diagnosis, along with a co-occurring disorder of alcoholism, we would be looking at the petition for conservatorship or looking to conserve because of the primary mental health diagnosis rather than on the alcoholism. And then also there really does need to be this piece that the person is unwilling or incapable of accepting voluntary treatment. So I think I heard Gail kind of steal my thunder on one of my cases that I talk about around grave disability. So I think all of you you're looking at this definition and you're saying your loved one automatically fits the criteria for grave disability. But this definition and actually proving it in court are two very different things. There are a lot of things that go into proving grave disability. There's a lot of law, case law, things where the appellate court and the Supreme Court of California have said, this is what it means to be gravely disabled. And so, just because, for instance, being homeless in and of itself does not make you gravely disabled. There has to be something else there that makes you gravely disabled. It cannot just be because you're homeless. So we have had situations in which trying to conserve individuals who are homeless has proven to be very difficult, even with them having a serious mental illness and having a difficulty being able to provide for their basic needs. I'll talk a little bit about that when I talk about our home pilot that we've been doing, our conservatorship project that we've been doing. The other thing, and I think the case that Gail talked about was the case in which we had a client who had been chronically homeless for years, was in the jail. We got a referral from the jail, and he asked for a court trial. And at the trial, when he was queried by the court as to what he would do to provide for his food, clothing, and shelter, he indicated that he would sleep in a tent back at his homeless encampment, that he could get food and clothing from the homeless service providers in the area, multiple meals a day, and that, for bonus points, he would go and get medication at the hospital down the street. One thing and he was found to be not gravely disabled. The judge said, okay, it's not a plan that you and I would want for our loved one, but it is a plan for food, clothing, or shelter. And one of the things to be very important for you to know, we're not proving that the person is refusing medication. We're not proving that they need involuntary treatment. we have to prove that they are unable to provide food, clothing, or shelter, and that they don't have a suitable plan for that. And suitable really ends up being in the eyes of the judge. And so it is a very difficult process. I will not sugarcoat it in any way. And there are many reasons why public guardian won't actually support your loved one being conserved, because legally we cannot do so. Next slide. So for us, public guardian, if we accept that case, we will be appointed the temporary conservator of the person only. We get no authorization over finances during the temporary conservatorship. And the TCON, or temporary conservatorship, will be no more than 30 days. In fact, because we get referrals late in the hold process, we are often only a temporary conservator for 2 or 3 weeks. You must have a hearing before the 47th day of that hold, if you have the 3 holds in your county. Otherwise, your loved one must be released from the hospital. During the TCON, my investigator is going to review medical records, conduct a LexisNexis search to try and locate family if family has not been identified in the referral. We're going to consult with the treatment staff. We're going to interview family, friends, and significant others, conduct a face-to-face interview with the proposed conservatee, and at the end, submit a comprehensive report with our recommendations. As the county conservatorship investigator, we will make a recommendation whether or not your loved one should be conserved or not. And if we recommend conservatorship, we will recommend who we think should serve in that capacity. Next slide. So the other way that a conservatorship can come into our office is through an outpatient conservatorship pilot. They're actually kind of not a pilot anymore. We've ended our pilot. We're continuing the program in a limited fashion. Again, not every county accepts outpatient conservatorships. Referrals we do. And again, it was a pilot that was started through our board of supervisors. So we have one method in which someone can be referred on an outpatient basis, and that's through our Department of Mental Health directly operated clinics. These are not contracted entities. These are our directly operated clinics. The clinic psychiatrist can have a discussion with us about possibly referring someone, and we will consider that. These are for individuals that we look at as being chronically gravely disabled, so they do not meet criteria to be acutely hospitalized, but they do have repeated hospitalizations, and those should be recent hospitalizations. They should be medication non-compliant, and all alternatives have been tried but not successful, such as AOT, FSP, wellness centers. Any of those alternatives should be tried first. Again, this is not available to the contracted entities. It's only our directly operated Department of Mental Health. And that's because the statute is very specific as to who can refer. It's not any doctor. They have to be designated doctors. And the designation is either the acute hospital, or in our circumstance, we doctors in our directly operated clinics have been designated to make referrals. Third-party assistance may affect the decision to petition. Let me tell you about third-party assistance. This is one of those legal situations that we have where the appellate court has come down and said, if there is someone willing to help the individual help them with their basic needs, help them with their food, clothing, or shelter, they are not gravely disabled. So if you as a family member are willing to have your loved one live with you and you're willing to provide them food, clothing, or shelter, they are not gravely disabled. There's nothing public guardian can do about that. That's the law. That is called third-party assistance. And if we pursued that case, the court would, and your loved one, fought the court case, the conservatorship, we would not be successful in winning that conservatorship case. We do not get temporary conservatorships in the outpatient because they're not in an acute hospital. The TCON is there because that gives you the ability to keep someone in a locked setting in the acute hospital. With our outpatient ones, with the clinics referring, we are looking for placement in the community. We just do not have the ability to take someone who's living with, in the community and place them in a locked facility. Gail and Jim both kind of, talked about that. And then, family members will often say, well, the reason I want the conservatorship is I want to be able to deal with a problem in the future when they decompensate or when they need to be hospitalized. We cannot establish a conservatorship for that reason. When you go into court, the court is looking at, is the person today gravely disabled? It is not about, history necessarily. The court may or may not consider history in the evidence when they're reviewing that. They're really looking at today. Failure to take medications and be hospitalized multiple times may or may not be what the court will look at. They're looking at today. So we cannot establish a conservatorship because you'd like it for future, unfortunately. So that's our directly operated clinic referral process for outpatient. And then we have another one called the home team. This is a collaborative effort between our homeless outreach mobile engagement team from the Department of Mental Health, who is out engaging individuals who are homeless. And they're offering everything and engaging them, trying to get them medicated. One of the incredible things that's happening in our home team is that they are actually giving injectables out on the street to individuals. They may start them with oral medication and then they try to get them on injectables, trying to get them compliant with some medication so that they may be more open to housing in some setting. So there's some incredible work being done by our home team here in LA County with our homeless outreach. So this is intensive outreach and engagement to chronically homeless individuals who are, again, chronically gravely disabled. These are not the individuals who are going into the acute hospital on a regular basis. These are the clients that are sitting on the streets for years and years and years in the same spot, actively psychotic, but not really doing anything to draw attention to themselves. These are the individuals that we're really focused on in our pilot. They're unable to survive safely in the community. They're not, without the help of people giving them food, they would not be able to go get it themselves. They're not changing their clothes. They're never, wearing anything new. Like I said, they're sitting there, in the same spot for the last 2 years. They're having, problems with, bugs and ulcers on their body, things of that nature. And they're refusing all services. So in the event that the engagement and the offer of services does not prove to be something that works for the client, the home team and public guardian will get together. The home team has the ability to refer to the public guardian, and we will do an investigation on the streets. This is it's a small program, and we work collaboratively with our home team to review cases. We have a regular meeting to discuss potential referrals to the public guardian. Our goal is no acute hospitalization unless we need it for short-term stabilization. And our goal, again, is placement in the community with FSP services rather than in a locked setting. Next slide. For our outpatient conservatorships, it is nearly the same legal criteria, which is that you are unable to provide for your food, clothing, or shelter due to a mental disorder. But there is this added piece that is required in the statute, and that is the professional person who's recommending the conservatorship, that designated person, may recommend conservatorship without the person being inpatient, but the following things must be true. The professional person has examined and evaluated the person and determined that they are gravely disabled, and they have determined that a future examination on an inpatient basis is not necessary. So those a little added piece that we need to cover in terms of doing an outpatient conservatorship investigation. Next slide. So again, we are going to investigate accepted referrals. We may not accept cases. We discuss with our clinics and discuss with our home team which cases we're going to investigate. We will investigate on the street or wherever the client is at. And then we'll decide if a TCON is necessary. Again, because we may need to hospitalize somebody, we may get a TCON, but for the most part, we are not getting temporary conservatorships for the outpatient cases because they are not in the hospital. Next slide. Again, we may use TCON to initiate placement in the least restrictive setting. We're going to use a hospital for limited purposes, such as acute stabilization, medical clearance, or detox. We may go for a TCON Reese for medication noncompliance. I will say we are doing our first one of these after a year in our pilot program, so I have no idea if this is going to be successful, so it's something that we're testing. And then for testimony, one of the things that's very unique about our pilots, and particularly our home pilot or our home program now, because it's not a pilot anymore, is that the home team psychiatrist is actually the person that ends up testifying in our conservatorship hearing. And that's true even if the client would end up in the hospital or go to even an IMD on a TCON. Our home team psychiatrist is following the client all the way through to the end of the conservatorship process. So one of the things that this does is it relieves the doctor in the acute hospital from having to testify, and it helps us overcome a legal problem that we have, which is called the Sanchez Rule. One of the things about our conservatorship hearings is that you cannot testify to something that you haven't directly observed. So you have to be testifying about the interactions personally that you've had with the client. So that's why when we have a doctor, they can only testify to what they have observed. They cannot testify to what the social worker or anyone else in the hospital or anyone else attached to that case has documented. So this is a relatively new rule that we've had to deal with. Again, an appellate court decision which impacted our conservatorship hearings. So one of the things about the home pilot is that we have that doctor who has had ongoing contact with the client, maybe for months and months and months. And so they can talk about a lot of stuff versus an acute doctor who's in a hospital who's only seen the client maybe for a few days. Next slide. So in our home program, our home outpatient conservatorship program, once the permanent conservatorship is established, if it's established, we're going to arrange placement, establish benefits, and transfer that case to the ongoing case management. If the conservatorship is denied, the home team will continue to provide outreach and engagement. Next slide. So conservatorship is a last resort. If you haven't already kind of figured that out, the law is very specific that conservatorship is the last thing that you do, not the first thing that you do. Because it removes many of the constitutional rights that we all take for granted, it has to be a last resort, and that's pretty much a statutory requirement. Before a conservatorship is established, all suitable or viable alternatives to conservatorship must be investigated and or tried before public guardian can petition or recommend a conservatorship. So if we look at our outpatient, this is really kind of important on our outpatient cases. We need to see if all of the AOT, assisted outpatient, full service partnerships, outpatient clinics, wellness programs, all of those things have been tried first and have been completely unsuccessful, and the client is refusing services. The other thing to be very clear to understand about our outpatient conservatorships, public guardian will not establish a conservatorship unless there is a placement that has been identified and guaranteed to accept that person, because the last thing that we want is a conserved person still living on the streets. Next slide. When we talk about alternatives to conservatorship, what are those? So an individual is not going to be considered they're not gravely disabled if they can find a way to provide for their food, clothing, or shelter. I gave you that, Gail and I gave you that one story of the gentleman who came up with a plan. If they can articulate a suitable plan, and again, I put suitable in quotations because it will be the judge's determination. If they can articulate a suitable plan, and they will be found not gravely disabled and they will not be placed on a conservatorship. There is currently a lot of pushback in our court about the idea of conserving homeless. Is homelessness, the argument that you may hear from the public defender is that this is a lifestyle decision. And there is some concern about the public guardian trying to conserve individuals who are homeless. And we have seen a few of our cases fail solely on that reason, where the public defender has argued and the judge has agreed that just because someone's mentally ill and homeless does not mean that they should be placed on conservatorship. Third-party assistance. This is where, again, someone or something, an entity, is willing to provide food, clothing, and shelter to the proposed conservatee, and the proposed conservatee will accept that assistance. By law, they are not gravely disabled. If anyone decides along the process, hospitalized or anywhere along the process, that they articulate that they are willing to accept voluntary treatment, they will be considered not gravely disabled and will not be conserved. We cannot place out of state. So out of state placements, our powers are only good in California. So we will, that's another reason why a conservatorship would terminate or not go forward, is if the person is going to move out of the state of California. And then AWOL. In LA County, public guardian is going to terminate if the client is AWOL and that AWOL extends beyond 60 days. We can make different decisions on that depending on a case by case basis. We do extensive steps to ensure that we've tried to locate the client. We're looking at the jail locator. We're looking at the mental health records to see if somebody's been hospitalized. So we're making a missing persons report. So we're doing all of the things necessary to try and locate our conservatee, but if they are gone for more than 60 days, we will petition the court to terminate that conservatorship. Next slide. So just an important thing to know about grave disability, and I think I've mentioned this before, the legal standard of what we have to prove to the court is beyond a reasonable doubt. So this is just the same as if you were sitting on a jury in a criminal trial. All 12 jurors have to come to consensus that there is no reasonable doubt around the issue of grave disability. If even one juror, or in the case of a court trial, the judge feels that there is reasonable doubt and we have not proven our case beyond a reasonable doubt, the court can, or the jury can, go ahead and say that that individual is not gravely disabled. Next slide. So for public guardian, if we are appointed the conservator, we have investigators in our office and we have case management deputies. So that case will move from the investigator over to one of our case management deputies, who is then responsible for managing the daily life and financial affairs of the conservatee. For public guardian, we become conservator of the person and their estate. We're going to apply for benefits or become their representative payee. We're going to pay their bills. We're going to make sure they have personal needs money. We make all decisions about where, placement and medications, authorizing mental health treatment, seeking court authority for physical health or medical treatment if it's intrusive. Gail has said that, I think she thinks I have a magic wand over here in the public guardian's office, that somehow we can gain better access to placements than you can. And I would say, that's not always the case. I mean, unfortunately, one of the realities of mental health treatment in LA County and across the state is the fact that there is just very, very few options for placement. There are very few locked placements, what we now refer to as IMDs or subacute. The space is limited, and to be honest with you, every county is fighting for every available bed. So, me and my colleagues in the public guardian's office are all trying to place in the same facilities and in the same beds. It's very difficult. The other big problem is, of course, board and cares are closing down on a regular basis. The one thing that I will say that's a positive, there was significant investment put in by Governor Newsom in his budget that will help counties. They have to apply for money, but there is a lot of infrastructure money that was put into the budget. It's not ongoing money, it's not ongoing service money, but there was one-time dollars put into the budget that counties can apply for that can help to build facilities, build out capacity, and we are certainly hopeful, very, very hopeful, that as the counties start to get that money, you will start to see hopefully some additional capacity, bed capacity, and treatment options available in all counties, but certainly in LA County. Next slide. So I'm not going to go over all of this because I want to make sure I get time for Maria when she comes on at 4, that she has her time. But these are the powers that you will get if you become a conservator. They are specific. Like I said, every county is going to issue powers to the conservator. We happen to use numbers in LA County, so we number our powers. You know, power 12 is non-intrusive medical care. Power 8 and 8A have to do with psychiatric mental health treatment and psychiatric medications. Your letters of conservatorship may not look the same in your county. That's one of the things that, you know, kind of based on how the courts have set that up. But this is how they look. This is the types of powers that you can get in LA County if you become the conservator. Next slide. LPS conservatorships only last 1 year. The intent of the LPS was that the goal was that an individual who was going to be LPS conserved, you would hope that they would stabilize and recover to the extent that they would not need a conservator beyond 1 year. You can have a conservatorship continue year after year, but you have to go back to court every year. So prior to the expiration of the conservatorship, the treating doctor needs to evaluate for whether or not the conservatorship should continue for another year. If the doctor recommends that for public guardian, our attorneys are going to file a petition for reappointment. If you are the private conservator, you have to petition yourselves. And yes, can you go through this? Do you have to go through the same legal process? Yes. Your loved one will have a public defender. They can contest that conservatorship and ask for a court trial or a jury trial. You can have this happen on an annual basis, and we have many conservatees who contest their conservatorships annually. Next slide. Conservatorship termination. So public guardian is going to request to terminate a conservatorship when the client is found to be by the psychiatrist or public guardian to be no longer gravely disabled. Again, during that reevaluation process, the doctor may say that the person is no longer gravely disabled. Again, if the whereabouts are unknown for more than 60 days. For private conservators, if a reappointment is not filed, your conservatorship terminates by operation of law. So the conservatorship is for 1 year. There's an expiration date on your letters of conservatorship. If you do not do the process before that terminates and get those documents filed with the court, it will terminate by operation of law. And the only way to start the process again would be another hospitalization and a referral to take place. So you start the whole thing all over again. Upon conservatorship termination, at least for public guardian or public conservator, there's no longer has any legal ability to act on behalf of the conservatee. So once our powers terminate, there is no authority to act on behalf of the conservatee. Next slide. So I want to talk briefly about forensic cases. These are cases that are coming from the jail or coming from the criminal courts for individuals who are incompetent to stand trial. So there are statutory requirements as to when public guardians should get involved with these cases. If your loved one is in jail for a misdemeanor or a felony and someone declares a doubt, says that they lack the ability to understand the criminal court process and they are incompetent to stand trial, generally they're going to go off off to some program, probably a diversion type program, or they could go to the state hospital if they have a felony charge. It is only after those diversion and IST restoration services are unsuccessful does the public guardian be brought in, and the court has to order public guardian into those cases. We get a lot of these court orders. It's actually our biggest bit of business at this point. We get quite a few court-ordered referrals to get involved with individuals who are incompetent to stand trial. But one of the things that's this is going to be the case moving forward. Diversion programs must be tried first. Let me tell you that there was a new law passed just by a couple of days ago by Governor Newsom, where if your loved one is a misdemeanor incompetent to stand trial, they will no longer go through competency restoration. That has been removed effective January. That will be removed from the law, and they will be going to a diversion program. That will be the new standard. There is one caveat. The county must have a diversion program available, and your loved one must be accepted by the diversion program. But the law is really moving to a direction in which people will be diverted from the jail, and that they kind of get away from this idea of competency restoration so that they can still be prosecuted. There are similar things happening on the felony level. The state hospitals have a wait list of nearly 1,700 individuals throughout the state that are sitting in county jails that are waiting to go to the state hospital for restoration of their competency. And the state is doing everything in their power to try and divert those individuals to diversion. So they want the counties to take over some of this responsibility. And there's a lot of activity going on at the state right now to try and come up with a way to handle these 1,700 individuals. I will tell you, I'm going to put this out there. In the event that the state is unable to find a way to get the 1,700 people sitting in jail diverted into outpatient or community-based programs, the state is prepared to effectively close the state hospitals to all LPS conservatees. We would never be able to place anyone in a state hospital because they would need those beds for the ISTs. And so we would have to move everyone from the state hospitals over the next 3 years. This will be a serious problem for public guardians throughout the state. There are hundreds and hundreds of conservatees sitting in state hospitals receiving treatment because they need that level of care. But if the state cannot solve the IST problem, the incompetent to stand trial situation, the only recourse they have, and they have gotten approval from the state legislature on this, is to close the door to conservatorships and to require the counties to move all of their conservatees out of the state hospitals. We will know more in November when the work groups come up with their recommendations, and we will have a better idea actually probably between January and April of next year if this is going to become a reality for all of us. It would be a level of care that we would lose that would be very, very problematic. Other diversion programs that are available in LA County, assisted outpatient treatment is now an official diversion program that judges can refer to. Again, they have to have capacity and the ability to take the client on. Public defender has a few diversion programs, so I always speak to the public defender to see if they have a diversion program that your loved one might be able to access. And then there's a program through our Department of Mental Health called Court Linkages that will try to get your loved one into a mental health treatment program as part of the criminal, as a diversion from the criminal charges. So lots of things happening in the criminal justice realm, lots of efforts to not have anyone with a mental illness in the jail, and all of that kind of comes back to diversion. And I didn't mention this, but in LA County, there's actually a department called the Office of Diversion and Reentry that is not part of the Department of Mental Health. It's actually in a separate department that is coordinating a lot of efforts related to diversion. Next slide. I think that Gail told you about our new courthouse, fairly new. The courthouse is open. There is no requirement for social distancing, but masks are required, but the court really does not want you showing up at court. So in the event that you have a loved one that's recommended for conservatorship and we are recommending you to serve as conservator, you're going to be on WebEx. You will get the information on how to appear in court, but we are doing most of our hearings at the moment through remote technology. We are going kind of on a week by week basis right now to see when they may open up and require people to come back into court on a in-person basis. Again, this could at any time, the court could decide that everybody has to come back to appearing in court in person. But for the moment, it is still by WebEx. Next slide. Public Guardian is moving. So we have been in our offices here in downtown LA in the Hall of Records for almost 40 years. And we are moving. Our new address effective November 15th will be 510 South Vermont. This is the new Department of Mental Health headquarters in LA County. A new building has been built and all of the DMH programs are moving into the building. We'll be the last one that will be going into that building on the 15th of November. Our office will be unavailable November 15th through the 17th, so you won't be able to get a hold of anyone. After November 15th, the only two phone numbers that will remain in that will carry over is our information line, our main number, 974-0515, and my phone number will remain the same. But everyone else in my office will get new phone numbers. So if you happen to be working with someone in my office, they will have a new number after November 15th. You can always reach them by email. They will be keeping their email addresses. Next slide. So again, these numbers are only good through November 15th at this point, but I am giving you the names of individuals who, my management team. So if you want to reach out to them before that date, you can. And then I did happen to give you the deputy and the supervisor that are working with our home pilot. They're available to answer questions about that pilot. I need to stop calling it a pilot. It's not, it's our outpatient conservatorship program. We're still stuck using the word, we're used to saying the word pilot. So that is contact information, at least for the moment. And I believe that's the end of it. And I think I'm only have about 5 minutes. So I'm not sure that we want to do questions right now because I'm afraid if we start asking questions, we're going to get into Maria's time. So maybe we can just hold questions to the end, Gail, and I'll be happy to stick around to answer any questions that anyone has.
Yeah, that would be fine. That would be fine. Connie, that was really extremely informative. Thank you.
Sure.
And all those pilots, it's amazing.
Yeah, we have a lot going on.
Yeah, that really is. Thank you. Actually, take a little break for everybody because I'm sure they need it. And then it's going to be on jobs, which how do we get jobs? So looking forward to that. Is Maria here already?
I am here. Listening to Connie. So, hi everyone.
Oh, thank you for doing this for us. I really do appreciate this.
Yeah, of course. Are you going to let people have a break? Is that what you said before we start, or are we going to move right in?
We can move right in.
Oh, okay.
Okay. And then we'll give them questions afterwards.